of the items of personal property that are disputed that my client indicates they no longer own because they, as we put, gifted to her parents.
And I would hope then that Mr. Dean, eventually you'll be able to provide appropriate documentation of the gift that was made. Council announce appearances for the record, please, beginning with Sarah.
Your Honor, the petitioner appears via Zoom with counsel, Paul Dean.
May it please the court, Your Honor, counsel, Geraldo Castaneda appears by and through counsel Jennifer Goheen by Zoom.
Okay, thank you. Counsel, we appear to have two consecutive cases that were filed in Greenwood County, begging the question, why did that happen?
Judge, I wasn't involved in the first case. My client apparently filed that pro se. I don't have an issue proceeding under the case number 2025 DM 25. I don't believe mom was served with the case of 2025 DM 24. I don't know how it happened that there was a case filed and then right after another case was filed. I don't know why that happened. Mr.
Dean, can you shed any light on this?
I apologize, Your Honor. I was only aware that we had filed a case. The court caught me off guard with that one. However, I believe Ms. Goheen's correct. My client I just inquired of her. She's never been served out of the pro se pleadings that Mr. Castaneda filed. He has been served, was served on June 5th in this matter, the 25 DM 25. And that's been filed with the court on June 6th. So I believe pursuant to general rules, this case would be controlling and the other matter should just simply be dismissed at this time.
So make sure that I understand, you're suggesting that the court dismiss 2025 DM 24 and proceed in the 25 case, correct?
Yes, Your Honor.
The court will make that order. Court finding that there are duplicative actions. Counsel apparently agree, and as does the court. The proper case to proceed in is the 2025 DM 25 case. Court will enter an order dismissing case number 2025 DM 24. This will essentially make Sarah the petitioner in the 2025 action and Geraldo the respondent. All right. We have a motion to modify the temporary orders which were apparently issued in the 2025 case. Ms. Goheen, have you talked to Mr. Dean about perhaps some agreements regarding modification?
Your Honor, we have not spoken, Mr. Dean and I. I don't know if we have just had schedules that are out of control, but we have not spoken. I did just receive a filing. He filed apparently this morning. I just got it, which was a response to the motion, but I've not spoken to him about it.
It was filed Friday evening, but I'm sure it just got populated out onto the Flex on Monday morning. I was able to finally sit down with my client person and review each of the numbered allegations and then try to key a response for ease of following to the same alphabetical numerical ordering that you utilize. I think there's a number of issues that we agree upon. I do have some objections to some of the requested orders for discovery, but my client has gathered them nonetheless. We just ask if the court's going to entertain that it's reciprocal. If not, if the court doesn't want to entertain that or make it reciprocal, we'll just forward out formal requests ourselves.
But let's work through this. What relief are you seeking today?
Judge, my motion is requesting the court modify the temporary parenting plan for my client to have shared residency. Currently, he gets reasonable visitation as agreed between the parties. Quite frankly, that usually just depends on if the mother agrees. My client has had limited parenting time with the children. I don't know if they agree to our holiday parenting plan or not, but that's included therein. I have told my client that the court may send them to alternative dispute resolution. But certainly we're requesting some parenting time, and my client would prefer week-to-week shared. They live 10 minutes apart. My client generally works from 7 a.m. to 5 p.m. He works at ASC Engineered Solutions, but his employer has, oh, I'm sorry, Judge. I just said that, and I was looking at the wrong entry. I'm sorry, he works for Harshman Construction LLC. And
Temp orders challenged, custody and property disputes heat up fast.
his employer has agreed that he can modify his hours so that he can accommodate picking the children up from school, taking the children to school. And so we're requesting that they have shared parenting time and adopt our holiday parenting plan. And we've requested that our child support worksheet be adopted as and part of that. And that's on file with the court. We are also requesting that that you modify the personal property provision. And there's some allegations about personal property here that mom's alleging they gave to her parents for some reason. I believe all of that can be worked out at a later time, but my client is asking for the Maxwell enclosed trailer and tools. He does use that for his employment because the construction company that he works for asks him to do certain things like carpentry things that are included in those tools that are in that trailer. And so we're requesting that.
Okay, Ms. Goheen, let's stop there. Mr. Dean, is there a problem with his recovery of this trailer and tools?
Your Honor, in our written response, we indicated that we don't really have an opposition to him taking it. However, it needs to be inventoried before it's taken. This is a divorce where the parties have limited assets. We dispute that he's using it for the Harshman rock construction quarry. Again, if he has got extra work or construction jobs, then we probably ought to be seeing proof of income from those positions, which we're not. We're just seeing it from the construction side. But it just needs to be inventoried. My client doesn't have a particular use for that trailer, and that's what we put forth in our response.
All right, so when would it be contemplated that this trailer and tools be turned over?
Your Honor, I think the respondent, Mr. Castaneda, could contact my client at any time. They've been communicating via text and make that arrangement. I have text messages where she was trying to make it available to him to come pick up whatever properties he wanted as far as his personal effects. She was wanting to wait till court to find out how we were going to proceed in regards to the trailer. And of course, we do need to get an inventory. And if they could both work on an agreed inventory, that would be fantastic.
Judge, she's had this trailer since she filed June 5th. So I would assume that she has like inventoried what's in there. If she has not, that's fine. I would just suggest that she have that done so that he can pick up the trailer this weekend.
It certainly seems to be a reasonable request under the circumstances. When this weekend, Ms. Goheen? I think we want to establish a date and time here.
Certainly. What day works best for you?
Tomorrow, whatever.
Well,
This weekend.
this coming weekend. It's Labor Day weekend. Do you want to do it Saturday or Sunday?
Saturday.
Saturday, what time?
Early in the morning.
9 o'clock.
Oh, no, Saturday, church. So Sunday will be okay.
Sunday at 9? Okay, Sunday at 9 a.m.
Very well, the court will so order. I will expect that the parties will exchange that trailer and tools at 9 o'clock a.m. on Sunday, August the 31st.
Judge, he also has some personal property and tools that are stored on the petitioner's parents' property. And I don't know what.
Why are they there?
They have a 40-foot storage container that they have on the parents' property. And they just had it there.
Your Honor, may I reply?
Certainly.
Some of the items of personal property that are disputed that my client indicates they no longer own because they, as we put, gifted to her parents. They were gifted to her parents, and that storage container is there is because the respondent petitioner resided at my client's parents' home for the last 3 years, paying no rent, utilities, or anything of that nature, prior to buying a house in Madison in September of 2023. So that's why, and we put that forward in our response to the motion. But there's some tools that we can identify. That's fine. We can get those
Yes.
to him, but we probably need to know what he's looking for. But that's why those items are at the petitioner's parents' residence, which is just south of Madison.
And I would hope then that Mr. Dean, eventually you'll be able to provide appropriate documentation of the gift that was made.
I think
Like
it was
a
just
statement?
probably, well, sure, Your Honor.
All right.
Then Judge,
Absent some showing that it was absolutely necessary for Mr. Castaneda to have immediate access to those items, the court's not inclined to disturb their current possession. I do encourage counsel, though, to work on perhaps an exchange if deemed appropriate.
and Judge, can you provide a date at which they're going to provide us documentation of this cash gift? Or this gift of this personal property?
Mr. Dean?
Your Honor, I assume at this point in time, because this was an informal matter, in other words, there was some horse panels, a portable shed that they had on the property that they just left and said, this is for us living here for 3 years, cost free. I suppose we can gather affidavits, et cetera, of that nature, and that's what we presented.
I think the difficulty is that my client gave them $400 a month when they were living.
No, I can get,
Which I presume he can document.
Certainly, I mean, it's cash, but I'll look and see if we have bank statements where he pulled that out.
The court will require both parties to provide documentation of their respective positions on this issue within 21 days.
Thank you, Your Honor.
All right.
Then Judge, and this may just require a walkthrough. My client has personal property at the
The
house,
court guides them on inventories and proper documentation for fairness.
including his computer that remains at the house. There's more than one computer. There's 2 computers in the house. He was only allowed to take his clothing and his truck. So perhaps we could agree to a walkthrough, and if they can agree to the removal of certain pieces of property, great, he can remove that. Otherwise, he can make a list or make a video when he's going through the house. And if they can agree on what he can remove, great. If they can't, then we'll make a list of that property and bring that issue to the court at a later time.
Mr. Dean, your client's position in that regard?
Your Honor, in regards to the computer, we don't know what the second computer is that he's talking about. The computer is utilized by the children for schoolwork. However, as we indicated in our response to pleading, if he wants to take it, he can take the computer. If he wants to do a walkthrough, we're not going to object to that for an inspection of the premises to make a list and then make sure that we're in agreement. That's fine. We just need to get that arranged, and I would prefer not to do that this coming Labor Day weekend because I will be out of town and would like to, when we're talking about a formal inspection, we'd probably like to be available for my client.
Okay, you trailed off there at the end because I was contemplating the parties just doing this on Sunday morning when he's going to be there anyway. And the problem with that is, Mr. Dean?
Oh, Your Honor, I was going to be out of town, but I could be reached. I don't really expect there to be any issue between these parties. I take it we could also make the court could issue a ruling if there's a dispute as to the removal of a particular item. That item will just be noted, set to the side, and addressed with the court at a later date.
The court
And
would
Your
then
Honor, my client tells me that he believes he can get someone from the church to stand by while they do that, just in case there's any problem.
That's fine.
Would this be someone that both parties know? Certainly a trusted third party on both sides. It would seem to make sense.
We can do that. If mom doesn't know them, then we can have her get somebody from her church, just so it's a third party. And we can make that happen. I'll have my clients give me some names before he leaves, and I'll give them to Mr. Dean in the hopes that we can get that done.
Okay. In many marital situations, the parties know who should have what. And I would ask the parties to be reasonable in that regard. However, I think Ms. Goheen, your client needs to understand that if there is a dispute with an item, he has to leave it behind
Sure,
at this stage. It doesn't mean he relinquishes his claim. It just means he can't take it with him that particular day.
that's fine, Your Honor.
And
He
I would ask her
understands.
not to be arbitrary in that regard. The more we can take care of things now, the better.
Yeah.
Yes, sir.
And then, Your Honor, the next issue was for the petitioner to pay the mortgage payment and her vehicle loan. I just skimmed through what was filed this morning. It looks like she is willing to do that. There is a dispute regarding extra income. Apparently, she claims my client is working additional jobs. He claims that she is working from their food trailer. I think all of that can be worked out at a later time. Because quite frankly, we're not going to resolve that here today. We are requesting that she provide a copy of her last pay stub from December of 24, her 24 W-2, and her most recent pay stubs. And my client will reciprocate. I don't think that's an inappropriate discovery request, considering the child support worksheets contemplate that. I would also note that we just want documentation of the cost she pays for medical, dental, and vision for the family, which I wouldn't anticipate there's a problem with that, as well as what she pays individually.
All right. Any issues with any of those requests, Mr. Dean?
No, Your Honor, we just requested that they be reciprocal. My client has actually gathered the majority, if not all of that information, save the health insurance plan available through her employer. She's reached out to the HR department, which is not located, unfortunately, within the state of Kansas. I believe it's located in a northern or northeastern state. She's waiting for a response. But that's where we are with that. I actually have a stack of documentation that I will take to my office to have scanned in and provided to them. Again, we just asked for the same in regards to because one thing I need in addition to what was just requested is also, I see on their proposed child support worksheet, they have $448 per month in health insurance costs associated with the children. We just need to verify that that's the actual cost associated with just the children. And there shouldn't be an issue with providing that either, I wouldn't think.
Is the wife currently on his plan?
Yes, there is insurance through her employer as well, but they're all currently on his plan.
All right. That needs to be taken into account, obviously. As far as the discovery matters that we've addressed, I appreciate the cooperative views taken by both attorneys in this case. But let's set the deadline consistently with what the court established earlier at 21 days for the exchange of this information, which obviously the court intends to be reciprocal.
Sure.
All right. Ms. Goheen, anything else except your request for modification of parenting time?
I don't believe so, Your Honor.
All right. And you're requesting that the court establish a temporary week-to-week shared custody schedule?
I am, Your Honor. My client has requested that. I haven't seen anything in their discovery that disputes he's an appropriate parent in this particular case. He did get to have parenting time this last Sunday. He got to take them to church.
Parties navigate logistics, timing, and cooperation while protecting kids' interests.
And when he requested to take them to church, mom's position was, well, where are you taking them to church? So I think there's some control issues here that may or may not be valid. I don't know. I've not seen one allegation, and I skimmed through their response, and I don't see any allegation here that he is not an appropriate parent in this particular case. If the court is inclined to not modify parenting time, I'm asking you to make a parenting time schedule if you're going to send them to alternative dispute resolution without modifying the schedule. And I talked to my client briefly, and he would request Tuesdays after school until 8, Thursdays after school until 8, and every other weekend from after school until Sunday at 8. like I said, I don't know why he would have to do that. He's a fit and appropriate parent. The children had a great time with him. He's always had a good relationship with the children. There's never been an issue with respect to that. There's no accusations of domestic violence. There's no accusations of abuse in this particular case. And as I look through the response, there is no allegation of that at all. There's an allegation he hasn't seen the children, and my client would contend that's because of the petitioner in this particular case. And so he is requesting shared parenting time.
All right. And he's the one that moved out of the marital residence, correct?
Yes, after he was served.
Understood. And then he's relocated to what residence?
He lives 15 minutes away. I'm sorry, 15 minutes away. He had to find a new place to live, and I believe that residence is in Hamilton, Kansas. So they're not very far away from one another.
Okay. And he has suitable accommodations for two children, one apparently around 15, one's about 10.
Yes, Your Honor. And he, there were a little bit of concerns that the house wasn't up to par. So he enlisted a friend of his, and they've changed things out in the house, and it's appropriate for the children.
According to him.
Yes.
Okay. Has the mother had an opportunity to view this place?
No, Your Honor, he hasn't even actually told her where it is because of the small nature of the community. She did see his vehicle at a residence in Hamilton and assumed that that's the location, but that information has not been shared with her. Your Honor, the respondent has requested visitation since Father's Day twice. Once. He's complied with every visitation request he has made to my client. She's not disputed. And I just read the text messages this morning, I guess, making kind of a proffer. But there's been no denial. There's just been very little request. Therefore, we'd ask the court to deny this request for any type of a shared parenting plan at this point in time, or the parties to go to mediation to try to work that out. These children are old enough, as we did reference, that the court may even, if mediation is unsuccessful, consider appointing a guardian ad litem to gather some of their input in regards to parenting plan in this particular case. We have noted a concern. One, that concern is essentially there's been multiple threats of the respondent when there's issues between he and Ms. Castaneda of taking the children to Mexico and keeping them from her.
Yes.
And that is why we did put a request that he be ordered not to leave the state of Kansas with the children. The passports have expired, according to my client. I believe she has physical possession of those. But that has been a concern. We don't know whether it'll be acted upon, but it's just a threat that's been made. And at this point in time, the parties are in a divorce. Further, Your Honor, the children participated in, there was no order saying that Mr. Castaneda couldn't attend any of the extracurricular activities the children have been involved in all summer long, including summer league basketball, summer softball, and Mr. Castaneda never made it to one of those events. Those were public, and my client provided him the list. Those are public events that you can walk into the Madison gym and watch them play basketball against the local teams all summer long. And softball is played on softball field right there in Madison and on the home games, even if it wasn't possible to get away to an away game. And those are generally in the evening after what I'm hearing everybody's work schedule would end. My client does live there in Madison. She works from 8 to 4:30. She works in downtown Madison at what everybody refers to as ABZ Valves, but it's the ASC is the company now. It's the valve manufacturer that's been in Madison for 60, 70 years at this point in time. So she's within minutes of the school, or if the children need anything. Understand, Mr. Castaneda doesn't live that far away in Hamilton, but I believe the where he works at is not necessarily that close proximity during the day for his work hours. So, Your Honor, we would ask the court to just leave things as is. My client is agreeable to reasonable parenting time, if she's not denied any parenting time, and get the parents to mediation to where they could hopefully work this thing out.
All right, Ms. Goheen, what would the start and end times be for the Tuesday, Thursday visitation?
The
That
judge ensures responsibilities and communication between parents are clear.
that would be from after school until 8 p.m.
He's able to get off work and pick up the kids after school?
Yes, Your Honor, his employer has said they will make it work with their schedule.
Okay.
And Judge, I would respond that my client didn't go to the Summer League games because the parenting plan says as agreed by the parties. And based on his relationship with mom, he didn't think he was allowed to go unless mom agreed to that. And so he's been very, very cautious. I would also note my client has said he has never threatened to take these children to Mexico. They have, if their passports have expired, he can't get them passports to go to Mexico without mom's permission, and the court can make an order to that effect, and my client would be fine with that. But there is no way he's taking these children to Mexico or threatening that, according to my client.
All right. Well, I think he was overly cautious with his interpretation of that order, which is not contemplated to prevent a fit and proper parent from attending activities, which I'm sure you've informed him, Ms. Goheen. But I am a little bit disturbed that he hasn't been more proactive in asserting his fatherly parental rights. It is the intention of the court that the father be involved in the lives of his children. In fact, very involved in the lives of his children, but it's something that he has to assert himself to do, not just for the court to order. However, I think we do need to get him on a structured schedule. At that point, there's no excuse regarding whether he's going to exercise his parenting time or not. Either he does or he doesn't, and then we can tell from that how committed he is to spend regular and consistent time with his kids. And every other weekend schedule, and the Tuesday and Thursday till 8 p.m. I'm hoping that doesn't in any way interfere with these kids' ability to get homework done. Homework in some school systems is kind of an archaic concept that they don't really do anymore. But if they do, if they have projects, they have schoolwork, homework, reading to do, father needs to make sure on Tuesdays and Thursdays that it gets done.
Judge, I would request that mom inform him if she's got any information regarding any homework that needs to be done. And he will make sure the children do that when they are with him.
So you don't think the kids would just tell dad that I've got homework to do and I can't play right now?
Well, if they are like my daughter would be like, no homework, no homework.
I think
No.
it's better practice for the parents to inform one another of those matters.
Yeah.
I mean, obviously, if my client knows of something, she would
Sure.
have no problem informing. But my kids go to the Madison School District as well, so I think generally any homework, it's just whatever gets assigned that day. So I don't think there's like some advanced knowledge unless the child's been out due to illness or something that, hey, these projects need to be caught up. Sometimes there are some projects throughout the year that they give you extra time to make sure that you get them done, or an extra opportunity to get them turned in, something of that nature. Sure. You can say, hey, you're coming up against the deadline to get project A completed and turned in, so you make sure you get all the credit. But I'm not judged. Do they give homework still in law school like they used to give to us, or you have to read all night long? Or have they done away with that even? I'm beginning to wonder.
Well, you just caused a traumatic flashback for the court, Mr. Dean. I do remember the extensive reading that was necessary each and every night to prepare for the next day. I would hope perhaps in public schools, perhaps there's still some of that.
I hope.
Even at that level, but I'll try to overcome that, Mr. Dean.
It's not pleasant memories for me either. I was not what you call a fast reader either.
I was the nerd. I loved reading. It was the math that really did not float my boat.
All right, Mr. Dean, as far as the weekend time, start and end time specifics, would you state those?
Oh, did you ask me, Judge?
Yes.
Sorry. I'm sorry. After school on Friday until Sunday at 8.
All right. And he does the transporting for these visits
Sure.
on both ends? Okay.
Sure.
All right. And when would his weekends start?
Judge, our parenting plan has Labor Day weekend and it has, I believe it has him having Labor Day weekend. I don't know if they have an objection to our parenting plan's holiday schedule.
Paul?
Yes, Your Honor.
Schedule. But if he wants them this weekend.
Yes, Your Honor.
As far as the Labor Day start?
My
adopting
client's
the
fine with
holiday
that,
plan?
Your Honor.
Okay,
That's fine. I was just discussing whether the kind of the nature of the visitation schedule. She said she would like to work more on the holiday schedule, but she was fine if for it to start this weekend.
yeah, I want to get these kids back with their dad for an extended period as quickly as possible. So we'll start his weekends on Labor Day weekend coming up.
And Judge, would he get the children until Monday at 8 p.m. then, since they don't have school on Monday?
If that's the proposed holiday schedule.
Thank you.
It's probably important we get this journalized sooner rather than later, Ms. Goheen. So if you can work on that as quickly as possible and get a proposed journal entry over to Mr. Dean. The request for shared custody is, of course, implicitly denied by the court. The court's certainly open to that being a long-term parenting plan in this case, depending on what's in the best interest of the children ultimately. It probably would be beneficial for these parties to sit down.
Child support calculations and temporary orders reviewed in detail. Court ensures fair retroactive payments and compliance from both sides.
Sit down, discuss the future of their children together with the assistance of a trained professional. Who would be suggested if this court were to consider ADR in this case, and what form, Ms. Goheen, would be appropriate?
Judge, I am fine. I mean, I don't know who all you're using over there. I've used Alex Flores. He's been very successful with parties, and he starts out with mediation. And then if the parties can't agree, he issues a recommendation, and he's fairly quick, which has been nice. But I'm open to whoever Mr. Dean suggests as well, or Cindy Cleos. I've used her before. And Stacey Ortega is swamped. Christina Retzlaff, I've used her, but I'm open to suggestions from Mr. Dean as well.
The one we primarily use is Deborah Dickerhoof, who used to be with Court Services in Lyon County. She's a trained mediator in this matter. She's retired from that position, but still does private mediation. She's very reasonable, and she's also much closer to the Madison area for these parties than anybody else would be, because she's right there in Emporia. So you're talking 20 minutes. And like I said, she was with Court Services in Lyon County for 20 plus years, but now she's retired. So I think she's also fairly quick to be able to get to parties as far as providing mediation services.
All right, that seems to be the most sound suggestion at this time, Mr. Dean.
And who is it? I'm
Her
sorry.
name's Deborah Dickerhoof. I'll have my office get you her contact
Okay.
information as well, and you can
That would be great.
check about her.
All right.
She does a good job.
All right. I think that's the best suggestion. I think my recollection is she is reasonable on fees, generally is able to address a case relatively quickly, and is in close proximity to where these parties live. So for those reasons, I believe that would be an appropriate choice. So if the journal entry in this case could so reflect. Mr. Dean, if you have any of her flyers or promotional materials, if you could please send those to Ms. Goheen.
I will do so, Your Honor.
Okay.
Thank you.
All right. All right, Ms. Goheen, again, I'm going to task you with drafting a journal entry stemming from today's proceedings, modifying the temporary orders that are otherwise in effect.
And Your Honor, we would agree that the child support will need to be modified, because we did not have the health insurance cost, but we were about 10,000 under what they were reporting for his income. But I would note that to date, there's only been one payment of $700 made towards child support, unless there's been something that's been paid and we're unaware of it. But so we're kind of starting to get a deficit there, and I don't think that's where we need to be starting out.
Well, we'll get that we'll get that fixed, but I do
Yeah.
believe Mr. Dean and I can figure out what the appropriate child support calculation is once we exchange income information.
Effective date of the modification, counsel?
Well, I would, whatever the correct amount for the health insurance credit and correcting the initial child support, I think it would just be retroactive to June when the court issued the order.
Ms. Goheen?
I believe the temporary order stated June 15th was when those were in effect. So I think that the motion to modify should apply to June 15th.
All right, and that was the first payment due under the temporary order?
Yes, sir.
All right, very well. Court will so order. And I would suggest that your client, Ms. Goheen, get caught up. Now, I realize
Absolutely.
he's been forced to relocate and establish a new residence. Court takes that into account, but he owes what he owes and he needs to subsidize his children appropriately. And I'm sure that you'll counsel him to get caught up on this child support, whatever it's determined to be, as quickly as possible.
We will, Your Honor.
All right.
And I didn't see any great discrepancies when I compared the child support calculations. The main difference was their request, the credits for essentially shared custody, and us lacking the actual information for the health insurance costs. So we shouldn't be an issue. If so, Judge, you can tell me that I was full of it when I told you it wasn't going to be an issue, and then we come back with a dispute. But I'm not expecting that.
I'll try to be diplomatic in my All right. Ms. Goheen, is there anything further that we need to address at this time?
Not at this time, Your Honor. Thank you for your time.
Mr. Dean, anything further currently?
Nothing further, Your Honor. Thank you.
I'll look forward to that journal entry being prepared and forwarded to opposing counsel and then hopefully placed into the court signature queue as soon as possible. If there's
Sounds good.
nothing further, then this matter will currently be in recess and the meeting may be ended for all.
Thank you, Judge.
Good day, folks.
Have a good day, everybody.
Mediation, long-term parenting guidance, and final court instructions, judge sets the path for future compliance and resolution.